Hi, this is Tom King, the founder of Toolkit.law. We're here with two attorneys who are friends of mine here in the state of Texas in the United States, talk about topics that are near and dear to them, domestic violence. And if you're in any of the 80 plus countries with English-based legal systems, they have created a great help sheet for you, a general approach for whichever of the 80 countries you're in on how to approach client and witness preparation. So we're here with Walter Schouten and Maisha Colter. Walter, please introduce yourself, and then Maisha.
Sure. So as Tom said, my name is Walter Schouten. I'm a family lawyer here in the Houston area. I'm with the firm of Toombs, Immel and Associates, and I do primarily split my time between trial level work and then appeals work.
And I'm Maisha Colter. I am the CEO of a nonprofit called AVDA, Aid to Victims of Domestic Abuse. I'm also an attorney and a licensed clinical social worker, and our primary focus is family law and representing survivors of domestic abuse and sexual abuse in family law practice.
Fantastic. Let's go ahead and go straight to the help sheet. This is a help sheet you put together in our domestic violence section, one of our 6 topics. This is client and witness preparation. Walter, start us off.
Sure. So y'all can see we've broken this up into 4 sections to try and make this as applicable to the audience as possible. And so this first section deals with understanding the unique challenges with the domestic violence client, because preparing these clients for a domestic violence case, or any case really where they may have to relive this trauma, presents unique challenges. A lot of these challenges come from having been traumatized, which Maisha, I think you can probably say something about.
So trauma causes a disconnection between the brain and the body, and it oftentimes will inhibit a person's ability to tell their story, to be able to be an effective witness. And so there are ways to help them overcome those barriers, and that's what we're going to talk to you about, how trauma affects the body, the brain, and a person's response to questioning and asking different particulars about their situation, which is something that if you're going to litigate a domestic violence divorce or custody matter, you're going to have someone be able to tell a story. And sometimes with trauma, it's hard to do.
I love how you put that trauma is a disconnect between the mind and the body. What a great, you've never used that, Jim, before in the other presentations we've done together. That's a good one. You pulled right out. Okay, let's go ahead and jump right into this. So you said understanding your client, understanding your case. What are the other 2 areas, Walter?
The other 2 areas are, of course, understanding your evidence, which will be related to understanding your case. And then, when we started working on this was really geared or set up from the perspective of the applicant or a person seeking relief predicated on family violence. But there's always a second
victim.
part of this,
A victim.
right?
Yeah, a victim.
Yeah, right. The victim, right? But there's a second part of this too. There's the person on the receiving end and the respondent. There's certain considerations that come with being in the respondent's position.
Absolutely. Let's go.
And uniquely, when we represent individuals, especially in the United States, most of our systems are adversarial. So there is not just a one person getting an opportunity to tell their story. We have to account for the other side and be prepared to defend, even though that is not necessarily the requirement that you have as as someone who's representing a survivor or victim.
So why don't both you walk us down the green column first?
Sure.
Sure. So I know Maisha said a little bit about trauma. I can tell you in my practice, in my own experience, 2 of the biggest things that I think you have to look out for is kind of how you manage your prep with the client, and then the things that you're doing with the client within that prep. And so because of the way that trauma can affect the brain, because of the variety of effects that it may have on different victims, you may have to set up your prep with the client differently. That often means shorter, more sessions for a shorter duration, because for a lot of these folks, going through this case or doing the prep may mean reliving the trauma, right? Do you have anything to add, Maisha?
One of the things that we think about with trauma and the negative impact on the brain is how it impacts the function of memory. And certainly because you're going to have to recount information about things that happened to them, when those things happen. And sometimes that affects whether or not they're credible or believable, their veracity. So if they can't remember these very traumatic events, then it makes people sometimes discount whether or not that reality happened to them. And so one of the big things that you, as the person who's probably representing a survivor, is to try to get into a position of allowing them to overcome that negative impact to their memory. And sometimes that might look like giving them ways to think about and remember events that are not as re-traumatizing as they might be. An example for
let's
that. What? Sure.
okay. Let's talk about how traumatic memories are stored. I found this interesting.
Mm-hmm. Yeah, so they're stored in senses. So you will see images, smells, sounds. Those things may help you to be able to recount and retell a story. And so allowing someone to recognize where memory is stored will be a good way for you to be able to prepare them for that retelling of their story in a court setting.
I want to add to that, to some extent, this ties into case presentation stuff too, because it can be difficult for victims to square their lived experience with the cold realities of the courtroom. The reality is you want your victim to look like a victim in the courtroom. And so as much as your client may not want to relive these scenarios, they still need to look the part. Okay. And so if you're working on a cold recitation of facts and your client gets up there looking like a robot, that may hurt your odds at getting the relief that you're seeking.
And of course, sometimes the victim may be the person that's accused of doing it.
That's true.
Absolutely.
And of course,
Absolutely.
Maisha, in your case, you always deal with the victims, right? You
Absolutely.
deal with the
Yes.
people who claim that there's something happened.
Mhm.
Whereas
Mhm.
Walter, in your practice, you deal with both sides.
Yep.
Okay, what else do we need to focus on in the green column?
The one other thing I'd add is in addition to having multiple shorter sessions, understanding that at the beginning, because of the way trauma manifests differently, you may have a client that data dumps on you, and you may have a client that doesn't tell you anything. The other factor is that once they start getting support from professionals like a therapist or an attorney or similar professionals, that they find their strength. And it may be the wrong time to find their strength, right? They get on the stand and they look combative because now they feel like they have the support to say what they need. So you just have to be on guard about those sorts of things and preparing your client.
Yeah. One of the things that is a simple thing to do, but I think it helps a lot, is to practice with your client in the setting. So even if you take your client to the court and they're not actually on the stand, but they're observing another hearing or proceeding, just getting them used to being in that space. They might have an opportunity to observe the judge who might be presiding over the matter. Obviously, if you're having a jury trial, you have a little bit of other things to think about in terms of how you approach, testifying to that audience. But like Walter said, sometimes the empathy is really, really critical. And so you want to have an opportunity for the client to convey their story that elicits a empathetic response from whoever the trier of facts is, whether it's a judge or jury, and getting them in that setting and getting them used to conveying their story in that space is also one of the things that will be helpful along the way. So think about how you can approach opportunities to allow them to be in the space where they ultimately will be telling their story, separate and apart from being in your office.
We're right on time to switch to the yellow column, understanding your case.
Sure. So I think a lot of this is probably self-explanatory, right? Know the law, know the judge, know what you need to prove to get your evidence in, but it's important to be mindful of it at every stage in the proceeding because you don't want a slam dunk case that you lose because you didn't know something that you knew, somewhere buried in your brain, but you just didn't refresh your brain, right? The other thing I wanted to say about all of this is know what happens at the appellate level, right? Because at least here in Texas, there's a really, really powerful principle in the Court of Appeals that the appellate court's really going to defer to the trial court. And so that is really, really powerful. Essentially, what the trial court does is probably going to stick in the Court of Appeals, and you need to know that going into a hearing.
Yeah. Yeah, definitely the idea of knowing your audience, whoever that judge is that you're in front of, make sure you prepare the evidence that you are going to present to them in a way that is very digestible for that particular judge. So sometimes some judges may be very fact oriented. They want to know dates, they want to know times. And so if you're in a court like that, you want to make sure that your client has the ability to recount dates, times of events. There are other judges that may allow you to have a more narrative testimony. So you're telling a story in the manner of like this happened on this day and then that happened later on, and it's not so specific, and they're okay with that, and you can get away with that sort of testimony. But recognizing who you are in front of and how that story gets told will allow you to be more effective. You know what, you can anticipate objections that might come from the other side. You might be able to anticipate again what is a persuasive evidence for one judge over another. Some judges look at the totality of the circumstances. Some of them are very conclusionary when it comes to if there was a physical assault, that's sufficient for them. Some of them look to a more collective story about domestic violence, whether that be economic abuse, emotional, and other tactics. So depending on who you are in front of, you need to be able to elevate the story so that the person who's hearing it understands and receive that story in a manner that ultimately is persuasive to them.
I loved this next box because regardless of whichever country you're in, there are some types of evidence that are in common, right? Photos and videos. And heaven forbid somebody posts something stupid on social media in any country, right?
Right. We love that. These are our wins.
But no, Maisha, you love that all the time. But half the time, Walter doesn't.
Yeah, well, here's the wrinkle, right? In some cases, you may not have any of this, and it may be a he said, she said. And so regardless of the side you're on, you need to be mindful of that, because the court can still say, at least in Texas, there's no documentary evidence. We don't have the photos, videos, greeting cards, whatever else that's listed here. But I believe this person that's saying they were a victim of domestic violence. And in Texas, that's going to stick, most likely. And so you need to be, this ties into what we talked about earlier in preparing your client to be credible and believable, but you need to be on guard with respect to that concept, regardless of the side you're on.
Let's finish these last two boxes. Go ahead.
No, I was just going to say, know how to get this evidence. So, I mean, obviously, your client, if they're the recipient of text messages, you are more likely than not going to be able to get that evidence pretty readily. But police reports, mental health records, make sure that you're, filing subpoenas, getting business records affidavits, so that when you do have this evidence that is supportive of your client's position, that you have the ability to go in, lay the foundation, lay the predicates, and get it into evidence. So that's another part of preparing your case effectively. So if you have this great evidence, know how to get it on the record.
Let's finish up these last two boxes with about 90 seconds per box, Walter.
Sure. So I would say the biggest thing about witnesses is twofold, right? One is to talk to them yourself. Don't take your client's word for it. Know what they're going to say. Understand that they may tell you something different than what they say on the stand. Just be ready for that. And then be aware of bias, right? If you've got your client's mom on the stand testifying, what else are they going to say than what your client needs them to say, right? Look out for that kind of thing. You're better off with what people would normally think of as a neutral witness.
No inside person. That's your best option in some of these he said, she said cases.
Yep.
What about the last box, Maisha?
Yeah, it goes to the same thing. knowing who your witnesses are, whether they've seen it firsthand, a friend, a family, a neighbor, police officer, and you might want to put them in a hierarchy. You may not need to present every single person who has been involved or have some knowledge of your case. Get your best witness. And I do like to start with that collateral witness who doesn't have a dog in the fight. That's usually pretty persuasive to anybody who's hearing this evidence.
A collateral witness. Okay, that's like two gems you've already shared. That is that. Have you heard that one, Walter?
Occasionally.
Okay, that's awesome. People who just happen to get involved by happenstance,
Yep, absolutely.
which in most cases you might think would lend to the greatest amount of credibility from a witness, right?
Yep.
Okay, we're on the second side, understanding your evidence. What did the two of you wish to share with this?
I could start this one off. I think this first concept ties into all the other stuff that we've talked about, right? Enhancing credibility and enhancing your odds of getting the relief you want. It is way more effective to walk your fact finder, your judge, or whoever's making the decision, walking them through a scene and how that impacted your client versus just saying he hit me or whatever the case may be, right? You want to show instead of tell.
Mm-hmm. Yeah, I believe in that. You want them to convey the fear that they had, the pain that they suffered as a result of someone physically assaulting them, the long-term impact of whatever it is that happened to them. So your questions should be nuanced, and again, it should be giving the person a picture that resonates with them, so that they say, yeah, I believe that this happened to this person, and I'm going to give them some relief because it's needed here.
Okay, keep on going.
Sure. Another aspect of this is making sure that your client, again, we're going to say this over and over again, can they be a good witness? Opportunity, tell them to outline things, give a timeline. It's a powerful thing to have someone just write down from start to finish, when these things happened, how they started to happen, and they go through, the most severe incident, the one that caused great harm, or that was witnessed by multiple people. Give them an opportunity to sort of recount and recall, and on paper is a very good tactic to do that.
Walter?
Okay, related to that, you really want your client involved in the hearing prep process at every stage. And so in addition to giving them homework to do, you want to review the evidence with them, make sure they understand what they're expected to say to get in their evidence, right? They need to know if they want to win, get the result they're looking for, they need to know what they need to say on the stand. I'm not talking about, making things up, but saying things in the most effective way.
Yeah.
And that includes
it kind
going
of goes
over the evidence.
Going over those, those concrete pieces of evidence, laying predicates. Sometimes, did you take this picture? Did your neighbor take this picture of the injury? And being able to lay the predicate and the foundation for certain evidence. So a picture, a text message. That's a little bit more technical and not necessarily about them recounting the information, but making sure that they understand that they have a responsibility to answer those questions in a way that allows you, the attorney, to get that into evidence. So that's really critical, is that you teach someone how to present, lay a predicate, lay the foundation for certain evidence.
Yeah.
Anything else in this column, Walter, of interest?
Well, we talked about the multiple sessions. A lot of these, I think, overlap with prior topics we talked about, but teaching them how to testify is important too, right? Because the courtroom doesn't line up with the real world. And taking testimony, at least in Texas and most of the United States anyway, is not having a conversation. And they need to understand that if they are answering questions in a way that they shouldn't be, there's going to be objections. It's going to feel terrible to someone that's a victim of domestic violence, but that's coming for them, and they need to be ready for that emotionally.
Absolutely. Yeah. And I think at the very bottom of that column is encourage work with therapists. So we actually have trauma counselors on staff as a part of our work. We have, people who meet with them on an individual basis. We have support groups, we have psychoeducation groups, and we do this because we understand some of the work that they do in that setting will ultimately help them in a litigation dynamic as well. So if you have the opportunity to refer someone for counseling and therapy and those things, especially if you know you're going to have a high conflict, very likely litigation type case, you want them to have that opportunity and take it for what it's worth and how it could potentially be an asset to them in their legal matter as well.
Yeah, and as an attorney in private practice, this is something, if I have trauma or domestic violence in my cases and my client's the victim, I will always advise them to work with a therapist. This not only gets them ready to testify, get them ready to potentially relive the trauma, it helps keep things a little more organized, right, as you get ready for the courthouse.
So now let's flip sides. Walter, I know that you and I have been in this case representing people who are accused, some appropriately and some inappropriately. What are the first thoughts that you have regarding the respondent's appearance?
So I'm going to go a little bit out of order. My first thought, if I'm representing the respondent, is there a criminal case pending? Because if there is, my client probably cannot testify, and I'm looking to make a deal, most likely.
So
That's probably the single biggest thing.
you're starting at the bottom.
I'm starting at the bottom.
Okay. Okay.
Because that obviously affects things. If my client can't get on the stand and testify, because I'm concerned about what's going to happen in a criminal case, and I am thinking about how I can convince the other attorney to keep it out of the domestic violence court and let's get some relief in place in another venue.
Okay. Maisha, what else on this column stands out to you?
Definitely presentation of the respondent is really critical. You want someone who presents well, who's very articulate, and that can go a long way with persuading a judge that this person, if the accusations are true, it's you doubt it because this person appears to be so well put together, so articulate, and they seem sincere, right? And so getting someone to a place where they present well and are prepared for cross-examination, if in fact they are going to be testifying, because sometimes my strategy as a person who's representing an applicant in a protective order or in a divorce matter is to get this person to show who we think they are at their core, right? Violent, volatile. And there are ways and tactics to do that in cross-examination. So you don't have to ask a question. You can be accusatory in how you approach someone as a respondent. You can say, you hit her on Tuesday. You hit her every day. You hit her, in front of the kids. And that's totally fair, right? And if that person responds in a way that is defensive, that can potentially get them volatile, then that lends itself to the credibility of your client's allegations, right? So you need to prepare this person to have a cool head, to have the ability to defend themselves, but to not be defensive, which is hard to do, right? With these types of accusations.
I would say too, as a general rule, if you're representing the responding party, you're taking everything that we just talked about and flipping it on its head, right? So if I'm the applicant and I'm on guard about bias with my witnesses or on guard about evidentiary predicates, I'm trying to attack that sort of stuff if I'm the responding party, right? And so if it's a therapist who claims to substantiate the abuse, I may draw out that therapist never actually saw anything. The therapist never actually met with me, didn't do any kind of formal assessment, things like that. So I'm taking what the applicant or the victim is thinking about, and I'm going to turn it over and flip it on its head.
Keep going down the column. We're doing great on time. Take as much time as you wish.
Okay. As far as the evidence is concerned, so there's two sides to every story. Are these text messages taken out of context? Do they have a credible response to why this thing or that thing was said? That's really critical. The other thing is, was there, mutual combat? Is this I took a defensive posture as opposed to I was a primary aggressor in a situation? Can they recount a story that was told by the other side, but recount it in a way that gives a credible reason for this person to have been physical with them. Was it I was restraining them? There's lots of things that you can account for in terms of why something may look bad, but it isn't necessarily bad. And it is certainly not me being an aggressive or primary aggressor in a situation. So can your respondent tell a story that deflects on some of the accusations that are put before them by that other party?
The other thing that comes to my mind is whenever you're doing text messaging, if you have temporary orders or permanent orders, that the texting in the United States insists that all texting be done in English.
Mm-hmm.
Yeah,
So
had that issue come up recently, actually.
Yeah.
Mhm.
yeah. Okay. Let's continue with the predicates and the applicant's witnesses.
Sure. So this is in line with kind of flipping all of the victim stuff on its head, right? And if you know that the person seeking the domestic violence relief hasn't demonstrated something that they need to demonstrate, you should object. You should point that stuff out, draw out the bias in the witnesses, um, point out that they haven't laid a predicate that they may need to lay, find some way to object to whatever witness they're going to call. Maybe they're offering a certain type of testimony that requires some other additional showing in your jurisdiction, but look out for any way you could possibly pick it apart on a technical ground.
Maisha?
Yeah. Yeah, and any witness that they have, you should have the opportunity to be aware of what the likely testimony is going to be, and to start asking your client, who is the respondent, do you know this person? Were they actually there when they say they were there? Do you have anything to defend on whether or not they were present? That day we were here and it couldn't have been this person. So think about the witnesses that they are going to bring and see how those witnesses can be undermined as well. And there are oftentimes, again, people who are willing to come out and help an applicant that may not necessarily have sufficient evidence to that should be considered. And so be prepared to defend and deflect and get those people out of the witness box.
I loved what you said, Walter, about the appellate issues, because I'll bet 90% of trial attorneys in the 80 countries with English-based legal systems never deal with an appellate court.
Mm-hmm.
Yeah, I mean they're not common, at least in family law issues and domestic violence issues in the state, or in Texas anyway. They're hard to succeed on because there's such deference shown to the trial court. And so issues of weight of the evidence, credibility of witnesses, the appellate court has to defer to the trial court here in Texas. And so that's powerful regardless of what side of the case you're on. And so with that in mind, I mean, I would sometimes think a little bit outside the box if you're the respondent, and maybe get away from the law when you're arguing to the trial court and focus on, like, for example, this impact on employment box. Convince the court that this is such far-reaching consequences to your client. This would be an unjustly harsh result, which is not something that's going to be persuasive to the Court of Appeals, but it might work for your trial court judge. And so you may have to think a little bit outside the box to not have to deal with sometimes case-ending appellate issues.
And now a topic that is surely in your area, but not in Maisha's area, having the client fall on their sword.
Yeah, this ties into, I think, being creative, thinking outside the box sometimes. You've got to be careful. If there's a criminal case pending, you obviously don't want to do this. But sometimes showing some remorse, if it's credible, might get you where you need to go. But this is kind of it's a tactical decision, right? You have to weigh this very, very carefully.
Maisha, I assume a DVPO is a domestic violence protective order?
Yes, it is.
Okay.
Well, I was going to say that in my practice, I have had some very persuasive and empathetic respondents, and I have had a judge say that I believe that you committed family violence, sir, but I also believe that you won't do it again. And it's because of the way that they approached the testimony and communicated to that court that I think they got away with it. So the protective order wasn't granted, and it doesn't happen often, but it has happened. So I will admit that is actually a tactic that works in some instances.
Okay, I'm going to ask you. I didn't tell you this before. What is your craziest family violence set of facts in a case that
I
you ever
have too
dealt with?
many. I really have too many. You know, I was
I had one where mom
on.
claimed. I had one where
I was.
mom. I had one where mom claimed that dad gave her guns and gave her marijuana, and that the child was an angel with mom until we showed the mom the pictures of mom with the daughter holding an AK-47 at age 15, and mom giving her big marijuana joint to smoke with the mom. What do you
I,
got?
you know,
What do you
I,
got, Walter or Maisha? You got something.
I don't know that I have any funny ones per se. Maybe one of the saddest I had was where we had no direct evidence that the husband had been choking the wife, but we had a recording, an audio recording, where you
Oh,
could hear a scuffle, a serious scuffle beforehand, and she testified to it, and you could hear her what sounded like being choked, but she didn't get the protective order because she came across as defiant and argumentative, and she found her strength at the wrong time, right? And so the judge wouldn't do it. He thought it was a tactical maneuver for use in the divorce.
wow.
Well, I will tell you, I have two pretty big ones. One of which was involved a gang, a famous gang, starts with an MS, years ago, and that one was pretty volatile, and it involved not only the husband who was a part of that gang, who was a leader. My client had forced sex and all kinds of things. She had tattoos on her body that we ultimately got an esthetician to voluntarily remove those tattoos from her. So that was a very nice result at the end, and we did get a lifetime protective order. And this is when it wasn't very popular to get lifetime protective orders. I have another one. I was on a Netflix series a couple of years ago. We represented a young man and his mother. We represented the mom. Dad took the young man from mom when he was about 5 years old. He then resurfaces after killing the father. So if you ever get a chance,
The
it's
son resurfaces after killing the father who abducted him.
correct. Correct.
Oh
It's called I Just Killed My Dad. It's still on Netflix. And so when I say I've had some real crazy stories happen, I cannot. If Netflix came calling, I probably have at least five more stories to tell.
okay, Maisha, I'm gonna watch it tonight.
Okay. Yeah.
I'm gonna watch it tonight.
Yeah. It's
So
yeah. Watch it. I'm on.
it,
I'm on episodes 2 and 3.
2 and 3. I killed my dad.
I just killed my dad.
I just killed my dad.
What a creative name.
Okay. Walter Schouten, Maisha Colter, thank you so much for this presentation, and thank you for joining us.
Thanks for having us.
Thank you.